5 seconds to go. Start. Particularly the immunity as available to the member of parliament in respect of anything said in parliament. The constitution bench observed thus, in our judgment, it is not possible to read the provisions of the article in the way suggested. The article means what it says in language which could not be plainer. The article confers immunity inter alia in respect of anything said in parliament. The word anything is of the widest import and is equivalent to everything. The only limitation arises from the words in parliament, which means during the sitting of parliament and in the course of the business of parliament. We are concerned only with speeches in Lok Sabha. Once it was proved that parliament was sitting and its business was being transacted, anything said during the course of that business was immune from proceedings in any court. This immunity is not only complete but is as it should be. It is of the essence of parliamentary system of government that people's representatives should be free to express themselves without fear of legal consequences. What they say is only subject to the discipline of the rules of parliament, the good sense of the members, and the control of proceedings by the speaker. The courts have no say in the matter and should really have none. This court held that the word anything is of the widest import and is equivalent to everything. The only limitation arises from the words in parliament, which means during the sitting of parliament and in the course of the business of parliament. It held that once it was proved that parliament was sitting and its business was being transacted, anything said during the course of that business was immune from proceedings in any court. This court, in the case of Lucknow Development Authority Supra, was considering Clause O of Section 2 of the Consumer Protection Act 1986, which defines service, wherein the word any again fell for consideration. This court observed thus: the words any and potential are significant. Both are of wide amplitude. The word any dictionarily means one or some or all. In Black's Law Dictionary, it is explained thus: word any has a diversity of meaning and may be employed to indicate all or every, as well as some or one, and its meaning in a given statute depends upon the context and the subject matter of the statute. The use of the word any in the context it has been used in clause O indicates that it has been used in wider sense, extending from one to all. This court held that the word any is of wide amplitude. It means one or some or all. Referring to Black's Law Dictionary, the court observed that the word any has a diversity of meaning and may be employed to indicate all or every, as well as some or one. However, the meaning which is to be given to it would depend upon the context and the subject matter of the statute. In the case of K.P. Muhammad Salim Supra, this court was considering the power of the Director General or Chief Commissioner or Commissioner to transfer any case from one or more assessing officers subordinate to him to any other assessing officer or assessing officers. This court observed thus: the word any must be read in the context of the statute, and for the said purpose it may, in a situation of this nature, means all. The principles of purposive construction for the said purpose may be resorted to. Thus, in the context of a statute, the word any may be read as all in the context of the Income Tax Act, for which the power of transfer has been conferred upon the authorities specified under section 127. The court again reiterated that the word any must be read in the context of the statute. The court also applied the principles of purposive construction to the term any to mean all. In the case of Rajkumar Supra, an argument was sought to be advanced that since section 35 of the Foreign Exchange Management Act 1999 uses the words any decision or order, only appeals from final order could be filed. Rejecting the said contention, this court observed thus: The word any in this context would mean all. We are of this opinion in view of the fact that this section confers a right of appeal on any person aggrieved. A right of appeal, it is well settled, is a creature of statute. It is never an inherent right like that of filing a suit. A right of filing a suit, unless it is barred by statute, as it is barred here under section 34 of FEMA, is an inherent right. See section 9 of the Civil Procedure Code, but a right of appeal is always conferred by a statute. While conferring such right, a statute may impose restrictions like limitation or pre-deposit of penalty, or it may limit the area of appeal to questions of law or sometime to substantial questions of law. Whenever such limitations are imposed, they are to be strictly followed. But in a case where held that the complaint filed was beyond limitation, this court reversed the judgments of the learned trial court and the High Court. This court, while interpreting the expression at any time, observed thus. Stop.